Lord knows settling a probate estate can be long and tedious, and the final phase of settling a Florida probate estate is the asset distribution process. Keep watching for a clear and concise overview of the asset distribution phase of estate settlement. It's understandable that after a long, perhaps difficult probate process, you're eager to get the final phase started. This is exactly when it's important to take a deep breath and make sure all of your ducks are in a row before distributing assets. It is imperative that before distributing any of the estate's assets to heirs and beneficiaries, you have followed the state's notice to creditor requirements and that you have settled all creditor claims according to state law. If you need help with any of this, be sure to watch our previous videos on creditor notice requirements and settling creditor claims. Understand that court approval is required before distributing any of the estate assets, which begins with the filing of a petition for discharge with the court. The court will review the plan and, if in agreement, will issue a formal approval of the distribution plan. Before any distribution actually begins, be sure to review the asset inventory and the appraisals of all probate assets. Confirm all appraisals and reconcile any discrepancies. If you need help with any of this, be sure to watch our previous video on inventorying estate assets. As much as we might wish that it were otherwise, heirs and beneficiaries do not always agree. It's important that you get your probate attorney involved in all distribution talks amongst the heirs and beneficiaries. An impasse with respect to the heirs and beneficiaries and how to distribute the assets may require third-party mediation be brought in or even a ruling by the court. When it comes to the actual physical distribution of individual assets from the estate, there are some options. For some assets, typically those of lesser value, direct distribution to individual heirs or beneficiaries is the way to go. For other assets, a direct division or direct placement with an individual heir or beneficiary might not be practical. For example, let's say there's a piece of real estate. You can't divide that piece of real estate into parts, and the value is such that giving it to any one heir would mean you don't have value to distribute to the other heirs. So the best solution in such a situation might be to have the real estate sold and then distribute the proceeds to individual heirs proportionately. If you're doing something like selling real estate, it's very important that you don't just hire any real estate professional to do that, but that you get a probate real estate specialist on your team. Other assets such as cash and other liquid assets can be divided up and handed out proportionally to heirs and beneficiaries. Also, individual items by agreement of the parties can be given to individual heirs and beneficiaries. With all of that having been said, remember, it's important to honor the decedent's wishes according to the will. Now, if there is no will, it's important that you follow the state's intestacy rules. Hint, intestacy is just a fancy legal word for there is no will. Also, when addressing distribution issues, there's nothing wrong with considering special requests. For example, let's say Patty loves grandma dining room set. Let's say Johnny could care less about the dining room set, but loves grandpa's motorcycle. The parties might completely agree, Patty, you take the dining room set. Johnny, you take the motorcycle. Now, just keep in mind, for any special requests, for any special agreements, your attorney may want to see a signed release from each of those individuals documenting their agreement for the file. Keep any disputes down the road at bay. Which brings us to final documentation. Ensure that all the documentation is gathered, an accounting of the estate assets, any receipts, any releases and agreements, are all compiled and reviewed for accuracy. Okay, it's the home stretch. Once all of the estate assets have been distributed to heirs and beneficiaries, the last step is to obtain a final order from the court closing the estate. And while you might think this final order closes the estate once and for all, that might not be the case. There may be post-probate considerations like the filing of final tax return for the estate. This is why it's vitally important that you keep your attorney and financial advisors tightly in the loop during this final phase. The last thing you want is to be faced with a final tax bill, all of the assets have been distributed, and there's nothing left in the estates to pay the taxes. That could get the personal representative personal liability, which is something you don't want. For more tips and insights, download our free report, The 12 Biggest Mistakes That Personal Representatives Make That Cost Their Estate Thousands. You can do that at www.floridaprobateMadeSimple.com. That's www.floridaprobateMadeSimple.com. For more videos on probate, estate planning, and related topics, subscribe to our channel where we publish new videos weekly. And of course, watch our next video.